Hello, everyone. I'm Alonzo Martinez, Associate General Counsel at HireRight, and this is Compliance in Focus, the third installment of our quarterly webinar series. While I'm a lawyer, today's webinar is not intended as legal or compliance advice. My intentions are to give you information that you'll take as talking points to raise with your teams and your legal counsel. That said, pick up your phone and snap that QR code to follow me on LinkedIn, where I post compliance-related content weekly. Before we begin, as always, I want to cover a few housekeeping items. During this webinar, please take the conversation to X using the hashtag HireRightWebinar. In order to receive HRCI or SHRM credit, you must attend the full live session of this webinar. Credit information will be emailed to you next week. We are not providing copies of today's slides. However, we will send you a link with a recording of this webinar session when we send you that email next week. If you experience any audio or video issues, please refresh the browser window by clicking F5 on your keyboard or send us a message using the Q&A icon at the bottom of the screen. Carrie is producing today's webinar and will be monitoring the feed for any technical issues. After the presentation, I would appreciate getting your feedback. Please take our brief survey and let us know if this session was helpful. My focus is to create sessions that are meaningful, so we welcome ideas for future topics. So again, please take 60 seconds out of your day and let us know what you think. And again, please press F5 on your keyboard to refresh this presentation anytime you experience any audio or video problems. Today, we are sharpening the details on the ever-evolving landscape of employment legislation and litigation. In the third quarter of 2024, we've seen legislatures across the U.S. continue to advance policies aimed at protecting employment rights with a growing focus on addressing emerging issues, things like artificial intelligence in hiring, privacy concerns, and equitable workplace practices. So as we look ahead to 2025, it's clear that these evolving regulations will further shape the future of compliance and the employment landscape. And that is exactly what we're going to cover today. You can see the rundown on the screen. I'll provide an overview of the current state of the law and offer some practical guidance to comply or to prepare to comply with those laws. And as always, we have a lot of ground to cover today. I'm going to try and keep a quick pace through these topics, so please do not consider this to be an in-depth discussion of any one topic, but it should provide you with a good foundation upon which you can explore. And I should mention that if you click on the resources icon in this webinar, you'll find links to material that will help you on your compliance journey. So those links are a great resource for you to bookmark. And in fact, I wrote an article that accompanies this webinar. It's the Q3 overview article. It should be the first or second link there. And if you are a note taker, that is a great place to take notes. Everything that I'm covering today is covered in that particular article, so check it out. As always, I'm looking for new opportunities to create content that benefits you. So when you fill out the survey, let me know what you'd like me to focus on in future webinars. Settle in for this next hour. And remember, if you have any questions during this webinar, use that Q&A icon and I'll try and cover those at the end. As always, we're going to kick things off today with a broad discussion concerning criminal history reform. Starting with a look at the landscape of ban-the-box jurisdictions impacting private employers at the state and local levels. In each of these jurisdictions shown on your screen, employers can't ask about criminal convictions until later in the hiring process, typically after a conditional offer of employment has been offered. In the jurisdictions shown in that red text, the law applies broadly to all paid work, including contractors and gig workers. Not all ban-the-box laws are created equal. Most restrict asking about criminal history during the initial application or before a conditional offer. That's what you see in that gray standard box. However, some jurisdictions, like those in that aqua column, require that you identify the criminal conduct that may disqualify the candidate from hire and provide them with a notice as part of the pre-adverse action process. And then there are those in that blue column that require that you conduct and provide an individualized assessment that relates the candidate's criminal conduct to their job as part of the pre-adverse action process. In Los Angeles and New York City, shown in that wine-colored column on your screen, you also have to provide additional city-published notices or substantially similar forms as part of the pre-adverse action process. And then, to complicate matters, there are 4 jurisdictions, Louisiana, New York, Atlanta, Georgia, and Gainesville, Florida, that don't specifically ban the box, but do require that you conduct an individualized assessment. As a reminder, an individualized assessment is your analysis of the candidate's criminal history and its potential relationship to the position for which they are under consideration. I've linked to an EEOC article that walks you through that if you're interested. While you do have to perform that analysis, that individualized assessment, you don't necessarily have to provide it to the candidate unless required by a particular jurisdiction's law. As you can see, you cannot adopt a one-size-fits-all model for compliance. You have to modify your adjudication and pre-adverse and adverse action practices to align with that particular jurisdiction's law. So with that said, just a quick reminder that you can use HireRight's compliance workbench solution to manage your ban-the-box obligations. The solution is free, no cost. So let us know if you want more information when you complete the survey. And a quick plug, you can find our Ban the Box white paper in the resources section of this webinar and in our resources library. If you're a HireRight client, you'll also find our sample pre-adverse and adverse action templates for your reference in Compliance Central within Screen Manager. Those were just updated in August, September, so they're fresh. Check them out. Moving on to the nation's most onerous ban-the-box law, and that's the recent ordinance passed that impacts employers in unincorporated areas of Los Angeles County. Again, unincorporated areas of Los Angeles County, not Los Angeles City, the rest of the county. First, it applies to any work for pay in unincorporated LA County. So traditional employees, contractors, gig workers, and freelancers, they're all in scope. Employers are prohibited from inquiring about an applicant's criminal history before extending a conditional job offer unless they're legally required. The ordinance has several notice requirements. For example, when an employer plans to review an applicant's criminal history as part of the conditional offer of employment, they need to list all of the essential job responsibilities in that job post. The employer must identify any tasks where they think the candidate's criminal history might make it hard for them to do the job and could cause the employer to withdraw a conditional job offer. So that's an interesting notice requirement for you. Once a job offer is made, employers can't inquire about an applicant's criminal record until they obtain the criminal background report. They have to share the report with the applicant before discussing any criminal history, asking for more details, or providing a questionnaire about that criminal history. So, practically speaking, this means that you can't ask an applicant to self-disclose their criminal history even after a conditional offer of employment has been extended. That, again, is very different and unique to this particular jurisdiction's ordinance. Okay, so let's walk through the sequence of events when considering an applicant's criminal history. Here's that life cycle. When considering an applicant's criminal history, employers must conduct an individualized assessment to determine if the history has a direct adverse bearing on the applicant's ability to perform their job duties. If the employer intends to take adverse action based on this initial assessment, they have to follow a specific process, including providing a preliminary notice of adverse action to the applicant, allowing them time to respond, and conducting a second individualized assessment if the applicant provides additional information. So let's break this down and talk about that modified pre-adverse action process. Once the employer finishes their first assessment and decides that they may revoke the job offer or take an adverse action, they have to give the applicant a pre-adverse action notice that serves as a warning. This notice should be sent by both regular mail and email. Again, that notice has to be sent both by regular mail and email if an email address is available, and that notice must include several things. The reason for withdrawing the offer or taking adverse action based on the criminal history, information about the applicant's right to respond before the final decision, the response deadline clearly highlighted in bold, underlined, or capital letters, and an explanation that the response can include evidence challenging the background check's accuracy or information on rehabilitation or other relevant factors. After getting that initial pre-adverse action notice, the applicant has at least 5 business days to reply. If they dispute the background check as being incorrect or need time to gather evidence for their defense, they get 10 more business days to respond. Then, what happens if an applicant shares evidence of rehabilitation or mitigating circumstances regarding their criminal history? So if they do that, if they provide such evidence, another individualized assessment is necessary. Then what happens if an employer decides to take a final negative action, like withdrawing that job offer after that second evaluation? After the second assessment, if the employer decides a final adverse action, then they have to inform the applicant in writing, again, by regular mail or email, if possible, of the And that adverse action has to include a final decision to withdraw the offer or take adverse action, a copy of that second individualized assessment, the convictions that lead to that final adverse action, information on how the applicant can challenge or request reconsideration of the decision, details on filing a complaint with the Los Angeles County Department of Consumer and Business Affairs, that's the DCBA, and the state's Civil Rights Department. And if the adverse action letter is sent more than 30 days after the applicant's response to the first notice, an explanation for the delay due to the emergencies or exigent circumstances beyond the employer's control. Notably, employers cannot withdraw a job offer just because of a delay in receiving a criminal report. But if waiting would seriously disrupt business and 10 days or more have passed since the criminal history request, the employer can take adverse action. The employer first has to tell that applicant in that initial notice why the delay is causing problems and follow proper notification procedures. You know that getting criminal records out of LA County can be a cumbersome thing. It can take several days. So if you're going to withdraw that job offer due to a delay, you have to let them know why. So that is the very highly complex ban-the-box ordinance that became effective last month for employers in unincorporated areas of Los Angeles County. Again, different from LA's ban-the-box ordinance, this is specific to unincorporated areas of LA County. For what it's worth, I've written a step-by-step guide that breaks down the ordinance in Q&A format, kind of like what we went through today. I've linked to that in this webinar. I encourage you to check it out if you have more questions. Let's keep it moving. Prince George's County, this is in Maryland, they've introduced updates to their ban-the-box ordinance through the Employment Fairness Act of 2024, expanding protections for individuals with criminal histories. The law now applies to employers with 10 or more employees, lowering the threshold from 25. Key changes include prohibiting the consideration of nonviolent felonies older than 5 years and misdemeanors older than 30 months. Again, nonviolent felonies older than 5 years and misdemeanors older than 30 months. Additionally, employers cannot consider arrest records that didn't lead to a conviction except for probation before judgment cases, which are now going to be treated as misdemeanors. Marijuana possession offenses are excluded entirely unless intent to distribute was involved. So, what does this mean? Well, this means that adjudication practices need to change. You're going to have to adjust those adjudication practices to stay compliant against the law. Think about that. Differences in how you consider nonviolent felonies older than 5 years and misdemeanors, no marijuana possession offenses, and probation before judgment cases, those are treated as misdemeanors. So how can you comply? Well, HireRight's managed adjudication solution can assist you in navigating these limitations. If you want more details, you can check out my article in the resources section of this webinar and let us know if you have any questions about managed adjudication when you complete the survey. Let's stay in Maryland, but talk about two important legislative changes that took effect on October 1st. First, Senate Bill 41 raises the salary threshold for reporting older adverse information in background checks from $25,000 to $75,000. This means that for positions with annual salaries below $75,000, only adverse information from the past 7 years will be reported. For roles exceeding that threshold, older information can still be included. So this change narrows the range of positions where extended background data is available, which means that less historical information will be provided for decision-making in lower-paying roles. Another call out for HireRight customers. Just a reminder that enabling the salary threshold feature is a configurable option. So let us know if you need more details when you complete the survey. Again, there is a salary threshold feature that is a configurable option. You can identify that salary that matters to you. Let us know if you need more details when you complete the survey. I want to move on to House Bill 622, which restricts what criminal records can be reported. Background check vendors like HireRight can no longer include cases where individuals were falsely accused, acquitted, had charges dropped, or had their records expunged. For employers, these changes mean that certain criminal records will no longer be available when conducting background checks. So be sure to review how these changes in Maryland might affect your access to information and adjust your decision-making processes accordingly. Big changes coming out of Maryland, all effective on October 1st. So Let's review the updates to FDIC Section 19, which impacts hiring in the banking industry. The updated rules introduce new exclusions for certain older offenses, offenses that are more than 7 years old, or for individuals under 21 at the time of conviction. 30 months after sentencing are now included. These are all exclusions from Section 19's restrictions. Expunged records, sealed or dismissed records are also no longer in scope. However, it's important to note that certain federal offenses, particularly those related to crimes of dishonesty, are still subject to that 10-year prohibition and will require FDIC consent before you can employ somebody with one of those 10-year barrier crimes. Additionally, de minimis offenses, such as minor infractions, are excluded if more than 1 year has passed and the offense was not committed against an FDIC insured institution. Drug-related offenses like simple possession are no longer automatically considered crimes of dishonesty, offering more flexibility for hiring individuals with certain convictions. One takeaway from these updates is the requirement for a reasonable documented inquiry into an applicant's criminal history, and the FDIC leaves it to your business judgment to define what's reasonable. That said, ensuring this process is thoroughly documented, that is what's going to be critical for you. So, what does this mean for you as banking employers? Well, you'll need to ensure that your background screening policies and adjudication processes are updated to reflect all of these new changes. In particular, updating your adjudication criteria, adjusting your adjudication criteria, really important. Ensuring your HR teams, compliance teams are documenting any criminal history inquiries and assisting candidates with FDIC consent applications when required, in particular those 10-year barrier crimes. So big changes coming out of the FDIC effective at the start of the month. Okay. As I mentioned at the top of today's webinar, this quarter, I'm going to be giving you some practical predictions about what you might see transpire in 2025. And for our criminal history reform section, I'm predicting more advancement on clean slate legislation. So on the screen is a look at clean slate laws across the United States. Clean slate legislation has rapidly grown. I was looking at a comparison over the last 3 years, and it's rapidly replaced ban the box laws at a rate of around 3 clean slate laws to 1 ban the box law over the past 2 years. These laws automatically expunge or seal certain criminal records after a designated crime period, after a designated period of remaining crime-free, removing them from background checks. States marked with a star offer automatic expungement, while others require individuals to petition to the court. Notably, Utah has shifted back to a petition-based system, while newer updated slate laws in Minnesota, Oklahoma, and Virginia will take effect in 2025. Wisconsin remains the only state without record sealing or expungement options. Many courts have struggled to implement these clean slate laws, creating a disconnect between what legislatures promise, what candidates with criminal records expect, and what the courts can deliver. That said, we should expect more clean slate legislation in 2025, and with that, fewer criminal records reported to you. That's the outcome. So to learn more about clean slate laws, check out our resource on automated criminal records relief, linked in the webinar materials. So let's walk through some actionable guidance as we focus on criminal history reform compliance. I'm going to reiterate, the key here is understanding that compliance can't be a one-size-fits-all approach. It varies by jurisdiction, so you're going to need to adjust your practices accordingly. A good place to start is by reviewing the compliance tools available to you. For HireRight customers, solutions like Compliance Workbench and our Managed Adjudication Service can help customize screening practices for each jurisdiction's requirements. Good solutions for you to look at. While the growing focus on clean slate and ban the box laws increases, your ability to inquire about candidates' criminal history, that may be restricted. So you'll want to review your self-disclosure questions and ensure that you comply with relevant state and local laws. For example, if you hire in unincorporated LA County, you may need to eliminate self-disclosure questions entirely. Last, I think it's really important to tailor your pre-adverse or adverse action letters to meet the specific requirements of each jurisdiction, especially in places like unincorporated LA County, where additional notices or assessments are required. And be sure to update your processes for Prince George's County, Maryland, and FDIC Section 19, as we covered earlier. Again, your adjudication practices have to change for compliance in Prince George's County, as well as if you hire under FDIC Section 19. So as we close out this section, I want to remind you to get your questions in using the Q&A icon at the bottom of the screen, and check out that resources section of the webinar for more information. Every item that I've covered so far has a corresponding article if you want to learn more. With these changes, it's more important than ever to regularly review your criminal background screening processes and ensure compliance with local, state, and federal laws. Again, let us know if you need to discuss changes to your accounts when you complete today's survey. And let's shift gears now and talk about pay equity and transparency measures. Remember that pay equity measures promote equal pay for equal work, and often include a ban on asking a candidate about their former compensation until some later point in the hiring process. And pay transparency measures require that you share a pay range with candidates, and in some cases with employees as well. So here is a map that I've created to show you the jurisdictions requiring that you either post or provide a salary range for any open positions. Most pay transparency laws note that the range that you publish is what you reasonably expect to pay the worker. And here is a table that breaks down the pay transparency laws with action in the third quarter. These are laws with recent or upcoming effective dates. Let's run through them quickly. In Illinois, employers with 15 or more employees must include a pay scale and a general description of benefits in job postings. This applies both to external candidates and internal employees for promotional opportunities and remote positions that might be performed in Illinois. Maryland's law, effective this month, requires employers to list pay ranges for any jobs performed, even partially in Maryland, covering both external and internal postings. Vermont's new law, also effective for remote roles tied to Vermont offices, requires that pay ranges are included and any tips or commissions as part of the total compensation be identified. Minnesota's law requires employers with 30 or more employees to disclose salary ranges and a description of benefits in job postings, ensuring no open-ended ranges. This applies to any job, including remote work linked to the state. Massachusetts, starting in July 2025, will require employers with 25 or more employees to disclose salary ranges and job postings, and upon request for promotions or transfers. Remote jobs tied to Massachusetts will also need to comply. New Jersey's new law, pending the governor's signature, requires employers with 10 or more employees to disclose salary ranges and benefits in job postings applicable to both in-state and remote roles based in New Jersey. And that is our overview of third quarter pay transparency legislation. Let's pivot now and talk about pay data reporting. We talk about this on occasion, and I wanted to focus on some new movement in this area. Starting with Massachusetts, which will require employers with 100 or more employees to annually report aggregated wage data by race, ethnicity, sex, and job category as a supplement to the federal EEO-1 report. Public employers, unions, and school systems meeting the same employee threshold must report this data every 2 years. Currently, the state's pay data reporting obligations are on hold, though, pending the potential federal implementation of similar requirements. I'm going to talk about that federal approach in a few minutes. If enforced, the state will publish aggregated wage data reports on the Executive Office of Labor and Workforce Development's website through their website. Again, that's the state's Office of Labor and Workforce Development website, though individual employers will not be identified on that state website. Employers are going to have to submit their first pay data reports by February 1st, 2025. Now, let's take a look at what may impact pay in 2025 with our preview. Starting with another pay data reporting law. New York City is considering one of the most comprehensive pay data reporting laws in the country. If passed, employers with 25 or more employees will need to submit detailed pay reports on employee compensation, including total salary, gender, race, ethnicity, and job category. This data is going to need to be submitted annually, making it one of the most stringent local requirements. Additionally, employers must complete a digital self-certification every 3 years, confirming their compliance with federal, state, and local pay equity laws. This is more evidence of the intent of New York City lawmakers to ensure pay equity across the workforce, kind of unique in this regard. While this proposed ordinance is still under consideration, employers should begin to review their pay practices now. Even if the law doesn't take effect until 2025, it's possible that 2024 pay data will be scrutinized under these new laws. This proposed legislation is part of a broader trend. I mentioned this. We've seen similar pay data reporting laws in states like California and Illinois, but New York City's could become the most far-reaching. So preparing your pay data systems now will help ensure compliance when these regulations are finalized. Again, we might expect to see that sometime before the end of the quarter, if not early next year. And then there is a possibility that federal pay data reporting requirements will make a return. A little bit of history. Back in 2016, under the Obama administration, the EEOC introduced what's known as Component 2 of the EEO-1 report, which required employers to report their pay data along with demographic information. Although the Trump administration halted this requirement, a federal court later ordered the EEOC to collect pay data for 2017 and 2018. Since then, the Component 2 requirement has been paused. Fast forward to today, the current administration has signaled an interest in reviving this reporting requirement. The EEOC's regulatory agenda suggests that we could see a new proposal as early as January 2025. So what does this mean for you as employers? Well, here are a few takeaways. While this isn't finalized yet, it's a good idea for employers to start preparing by reviewing past reporting requirements and assessing whether their current systems can handle future compliance. It's also a smart move to conduct a pay audit now to identify any disparities before formal reporting begins. You should consider working with legal counsel during this pay audit process. That can assure that the audit is protected under attorney-client privilege. So be sure to keep an eye on both federal developments and state and local specific pay data reporting laws to stay ahead of any potential changes. As we wrap our pay equity and transparency discussion, here are a few key takeaways. First, ensure your job postings, both internal and external, include salary ranges as required by state and local laws. Some jurisdictions also mandate disclosures of benefits, such as Vermont, which includes tips or commissions in its requirements. If your hiring process still involves asking candidates about their salary history, it's time to rethink that practice. Many states have implemented bans on these inquiries, and adopting a consistent policy across all locations will help ensure compliance. It's just easier. You might want to also prepare for paid data reporting with laws in states like California, Illinois, and soon Massachusetts, and potential local and federal developments. It's really important to review your paid data systems to see if you can comply. Conducting pay audits now will help identify any disparities before pay data reporting requirements begin, so it's a good idea. Finally, keep track of key dates. Keep an eye on upcoming effective dates for any of these laws, including Maryland's new pay transparency requirements and the federal developments on pay data reporting, which could resume in 2025. So by way of actionable guidance, by staying ahead of these changes, you can help ensure that your organization is prepared to meet any evolving pay reporting, transparency, data reporting requirements, and pay equity standards. Again, for more details, visit the resources section of this webinar, where you will find all of our pay equity and transparency information, including our ebook, and keep getting your questions in using the Q&A icon on the screen. And just a reminder, for HireRight customers, by default, our platform does not ask candidates to disclose their compensation history. And because I see this in the Q&A, for clarity, I know that you're asking about this already. The salary threshold setting that I mentioned in the criminal history reform section earlier is something that you as an employer would use to indicate if you expect to pay a candidate under or over a specific threshold, let's say $25,000 or $75,000, for example. It's not a process by which a candidate discloses their former compensation. I understand that that's a little confusing. Let me know if you have any questions. Great engagement by the audience, by the way. I really appreciate you getting those questions in. So let's move into our discussion of miscellaneous legislation and litigation. This is our potpourri section. It's stuff that's worth mentioning, but it doesn't fit in elsewhere. I like including it though. Let me know if you think it's valuable. I'm always kind of on the fence about this. Starting in January 2025, California employers need to be aware of changes introduced by Senate Bill 1100. Under this new law, you can no longer indicate that a position requires a driver's license in job postings unless driving is an essential function of the role or alternate transportation like biking to work or ride sharing to the job site is not a reasonable substitute. So you're going to want to review your job ads and remove any unnecessary driver's license requirements to ensure compliance. Though this change doesn't impact your background checks directly, it's, I think, an important update to keep in mind. So I just wanted to bring it to your attention in the event that you're involved with your job requisitions in California. Okay, so this update is admittedly a little weird. Again, I was on the fence about including this one, but stick with me through this one. Starting January 1st, 2025, Illinois Senate Bill 508 introduces new protections for employees whose work authorization documents are flagged by systems like E-Verify. So under this law, employers are required to notify employees of any issues related to their work authorization and clearly explain the problem. Very different. Additionally, employers must provide employees with adequate time to correct any discrepancies in their documentation. The law also gives employees the right to have representation, such as legal counsel during meetings or proceedings concerning their work authorization status. If a government agency flags an issue, employers must notify the employee within 5 business days, ensuring that they have time to contest the findings. In the case of I-9 inspections, employers are required to notify their employees within 72 hours, and the notice has to be posted in English and any other language commonly used at the workplace. One area of concern with this bill is its lack of clarity regarding whether it restricts or limits the use of E-Verify in Illinois. I've heard this from a few clients. Unfortunately, this bill is unclear, and that's probably an understatement. So you're going to want to consult with Employment Immigration Counsel for guidance on this if you hire in Illinois and use E-Verify. This is a good example of how the bill's drafters were well-intentioned to protect candidates' rights, but left employers between a rock and a hard place. This bill is not a great bill. Look at it. Tell me what you think about it after you've read about it. Contact me on LinkedIn. I'm curious. That is the very unusual SB 508 out of Illinois. Let me know if you have any questions. I quickly wanted to share a story with you. You might have heard about it. A recent case involving a North Korean hacker posing as a remote software engineer using a stolen US identity. It underscores the growing risks employers face with remote hires in particular. The rise of remote work has made it easier for bad actors to bypass traditional vetting processes. So, to mitigate this threat, employers might consider using advanced identity verification tools such as AI-driven biometric matching and liveness checks to confirm the authenticity both of identity documents presented and an individual. This incident highlights what we all know. There are real vulnerabilities in remote hiring. So, strengthening identity verification, fostering collaboration between HR and IT teams that can help protect your organization from some of these sophisticated threats. There's tons of incidents out there. It's becoming far and far more popular in the media. If you'd like more information about identity verification solutions, just let us know through the survey. I've also linked to an article that I wrote where I covered this particular case. Okay, let's shift gears and get some audience participation going. If you've attended my previous webinars, you know that this is my favorite part of this show. I'm going to walk you through a fact pattern and then ask you to decide the case. So listen up, here are the facts. I'm going to give you a little more backstory than's provided on the screen. I'm calling this one weed out or zero tolerance, and here is why. Okay, in this case, an employee in Illinois worked as a territory account manager for a manufacturing company. He worked from home, but he also reported to a regional office or a customer site on occasion, primarily from home though. The company maintained a zero tolerance drug policy that applied to both workplace and off-duty marijuana use. It's well documented in the employee handbook, which he received. The employee tested positive for marijuana use during a random drug test, which led the company to enroll him in their employee assistance program, their EAP. Under the EAP, the employee had to attend counseling and undergo further drug tests. Initially, the drug test tested negative. The employee tested negative after counseling, but later produced two negative dilute results, which the company considers failed tests. The company gave him one more chance, and after a final positive result for marijuana, the company terminated him. So, again, if you're keeping score, that's a total of four tests, two positive and two negative dilutes. The employee filed a complaint arguing that the company violated the Illinois Right to Privacy in the Workplace Act. This act prohibits employers from firing employees for using lawful products such as cannabis during non-work hours. However, the company claimed that it had the right to enforce its zero tolerance drug policy under the Illinois Cannabis Regulation Tax Act, which allows employers to maintain drug-free workplaces even when marijuana is legal. So those are the facts, and that is the complaint. So here is our poll question. You be the judge. Can the company lawfully terminate the employee for testing positive for marijuana under its drug policy, despite marijuana being legal in Illinois? Again, we have a remote worker who is using marijuana lawfully at his home, test positive for marijuana. Can the company lawfully terminate him? Let's get your thoughts in. Move over when we have at least 40% of you responding. We're at about 10% now. Let's get in a few more answers. We're at 20%. Get your answers in. You have a 50-50 chance of getting this right. We're now at about 25%. A few more of you, please. All right, we've got around 1,000 of you joining today, so let's get at least 400 responses in, and we'll move over. Okay, we've got more than half of you responding. So can the company lawfully terminate the employee for testing positive for marijuana under its drug policy, despite marijuana being legal in Illinois? Let's see what you think. The majority of you say yes. Well, congratulations. It is a win for the employer, and here is why. The central issue here was whether the company could enforce its zero tolerance drug policy after the employee tested positive for marijuana, given that marijuana use is legal in Illinois. The court's decision was based on three key provisions of the Illinois Cannabis Regulation Tax Act, the CRTA. First, the CRTA allows employers to establish and enforce drug-free workplace policies, including zero tolerance policies, even for marijuana use during off-duty hours. This means that employers can maintain strict drug testing policies without limiting enforcement to only on-the-job drug use. Second, the CRTA does not prevent employers from taking disciplinary action, including termination against employees who violate these drug policies. The company's zero tolerance policy was clearly communicated to the employee in the handbook, and the employee understood that testing positive for marijuana would lead to termination. Third, the CRTA provides legal protections for employers so long as their drug testing and disciplinary actions are reasonable and applied consistently. In this case, the company followed its policy fairly, giving the employee opportunity to comply through the employee assistance program before taking final action after multiple failed drug tests. The court determined that the employer acted well within its policy and well within its rights, as the CRTA explicitly allows companies to enforce zero tolerance drug policies, even when marijuana is used legally off duty. Since the company provided the employee with a clear policy and followed its procedures, the termination was deemed lawful. So, what did we learn? This case highlights the importance of having well-defined drug policies that are clearly communicated and consistently applied. Even in states where marijuana is legal, employers can enforce zero tolerance policies if they are reasonable and properly documented. That is our game today. Thank you so much for playing. I had fun. I hope you did too. Let's keep it moving. And here are a few compliance takeaways for you to focus on. First, starting January 2025, California employers must review and revise job ads due to Senate Bill 1100. Employers can no longer require a driver's license unless driving is essential. Next, Illinois Senate Bill 508 requires employers to inform employees of any discrepancies in their work authorization documents and allow time to correct them. And with identity fraud on the rise, you might consider using AI powered identity verification tools like optical character recognition and biometric face matching, especially for remote hires. And finally, Illinois employers can enforce drug free workplace policies, including off duty marijuana, if applied fairly. That case was a good segue into cannabis reform. You're going to hear me use the terms cannabis, marijuana, and THC interchangeably. They are the same thing. I tend to do that in my writing, so please do not let that confuse you. Again, cannabis, marijuana, THC, all the same thing for the purposes of today's discussion. So let's kick this session off by covering medical cannabis accommodation requirements. And I'm going to give you an important update from Pittsburgh. So different states have varying laws. In red states, employers are generally not required to accommodate medical cannabis use, as you see on the screen. Aqua states have anti-discrimination laws that require reasonable accommodation, meaning adjustments to allow employees to perform their job unless it creates undue hardship. Blue states, as seen on the screen, are silent, and Philadelphia, shown in purple, prohibits pre-employment marijuana testing. Now, here is some breaking news for you. Pittsburgh's new ordinance prohibits employers with 5 or more employees from requiring pre-employment tests for medical marijuana patients, except in cases of suspected impairment. Again, medical marijuana patients. This means that you need to update your drug screening policies and processes to comply. Exceptions exist for safety sensitive positions and collective bargaining agreements, and for cause post accident testing is still allowed. This ordinance was passed after I created this presentation, so I don't have a standalone slide on it. But again, no more pre-employment testing for medical marijuana in Pittsburgh effective immediately. So you're going to need to either ask your candidates post-offer if they are a medical marijuana user, or you'll want to remove THC from your drug testing panel if you hire them in Pittsburgh. This is an ordinance that doesn't make a ton of sense, but this is what we have. Just a reminder, all jurisdictions that have legalized marijuana that are federally regulated, and I'm sorry, just a reminder that all jurisdictions that have legalized marijuana, federally regulated and safety sensitive positions are typically exempt from those requirements. Make sure that your policies align with state and local laws. I plan to publish an article about what's happening in Pittsburgh on Friday. We'll also send out a communication to our customers before then. So just an FYI, you'll get more information from us regarding Pittsburgh very shortly. Here is our recreational map. As you can see on the screen, multiple states, 23 of them in fact, and DC have legalized recreational cannabis, also known as adult use legalization. In those red states, recreational cannabis laws do not impact employer drug testing policies. However, those states in aqua limit the ability, an employer's ability to take action based on a positive cannabis test. And in blue, states like California and Washington, pre-employment testing for non-psychoactive THC metabolites are prohibited. Those are those metabolites that make somebody feel high. You cannot test for non-psychoactive THC metabolites in California and Washington. Employers in these states have to shift to oral fluid tests or remove THC from their drug testing panels. And states like New York and Minnesota, showed in purple, pre-employment cannabis testing is generally banned unless specific exemptions apply. Just one note to bring you up to speed with what's going on in Ohio. With recreational marijuana sales starting in Ohio on August 6th, employers can still enforce their drug screening policies, including prohibiting off-duty marijuana use or impairment at work. It's important to remind employees of your drug-free workplace policies and ensure that they clearly outline that marijuana use is prohibited during work hours. Again, we talked about that in Illinois. Making sure that your employees are aware of your drug-free workplace policies is really key, especially with recreational marijuana sales now beginning in Ohio. And a quick update out of Minnesota. As of January 1st, 2025, employers can now use oral fluid testing as an alternative to traditional drug tests for applicants. This new testing option is available upon request from employees or applicants, and the standard notice and retesting procedures that are existing in Minnesota, they still apply even with oral fluid tests. So that is our update out of Minnesota. So let's take a look at what we're tracking drug testing wise out of into 2025, starting with the DEA. The DEA is proposing to reclassify marijuana from a Schedule 1 to a Schedule 3 drug. This change would recognize its medical use, but still keep it regulated under federal law. While this wouldn't fully legalize marijuana, it would make it easier for researchers to study and develop medical treatments. For employers, especially in safety sensitive industries, this shift could complicate could complicate your policies regarding medical marijuana use. You're going to want to review your drug policies and consider how this rescheduling could affect your employee accommodations and workplace safety. Again, I think accommodation of medical marijuana use will be one of the key changes that will happen if rescheduling occurs. A public hearing on this proposal is scheduled for December 2nd, 2024. Employers can provide input, and we've included a link to my coverage of the DEA's proposal and to the hearing in the webinar's resources section. So if you want to attend that hearing, look for that link in the resources section and join on December 2nd, 2024. Several states have upcoming marijuana ballot initiatives that could impact employer drug testing policies. What are we tracking? Well, voters in Florida, North Dakota, South Dakota, they're going to decide the fate of recreational marijuana in their states. Meanwhile, Nebraska is focusing on medical marijuana with 2 measures to regulate its use. While these initiatives could lead to changes, most are not expected to significantly restrict employer rights. However, it's important to monitor these developments and adjust your drug testing policies as necessary. So let's look for some new news to come out of Election Day concerning marijuana. Let's talk shrooms. Massachusetts voters will soon decide on question 4, which would legalize natural psychedelics like psilocybin for individuals 21 and older. This follows similar actions in Oregon, Colorado, and several U.S. cities since 2019. Even if psychedelics are legalized at the state level, federal law still applies, and employers can maintain drug-free workplace policies. For most employers, this means continuing to prohibit the use of psychedelics on the job or while impaired at work. You'll want to make sure that your policies reflect that. Speaking of, as we wrap up here are the key takeaways regarding cannabis and psychedelics. First, focus on workplace impairment rather than zero tolerance policies for off-duty cannabis use, especially in states with evolving marijuana laws. Again, zero tolerance policies are absolutely fine, but looking at workplace impairment is really what is key. Second, you're going to want to make sure that you update your testing methods in states like California and Washington, where pre-employment testing for THC is restricted. You'll want to switch to oral fluid testing or remove THC from your drug panels. And if you hire in Pittsburgh, make sure that you either ask candidates if they are medical marijuana users post-offer or remove THC from your pre-employment drug testing panels immediately. It's no longer permitted. Here is your call to action. You need to make sure that your drug testing policies, practices, and screening panels align with these evolving regulations. There's a lot going on in the drug testing space, so keep informed and adjust your programs accordingly. Speaking of, know the law. Make sure you understand state-specific regulations on both medical and recreational marijuana, as well as the potential impact of psychedelic legalization. That's occurring at the local level as well, for what it's worth. And remember, all marijuana legalization laws exempt federally regulated and safety-sensitive positions. Again, all marijuana legalization laws, recreational or medical, exempt federal regulated and safety-sensitive positions. I'm getting a lot of questions about that, so I just want to make that clear. That is our cannabis and psychedelics update. Continue getting those questions in using the Q&A icon at the bottom of the screen. Check out the resources section of this webinar for more information, and let us know if you need help adjusting your drug testing panels when you complete the survey. We are right on track to zoom through some privacy, tech, and employment updates. First, I created this map to show you all current and soon to be effective data privacy laws. Newly passed laws are indicated by a star, and newly effective laws are shown in aqua. As a reminder, all states that have passed a data privacy law have exempted information collected and reported in compliance with the Fair Credit Reporting Act. This means that background checks, when conducted by a background check vendor or a consumer reporting agency like HireRight, are excluded from the scope of these privacy laws. And here is a map that I started working on last quarter, and it has since evolved to track the progression of AI laws impacting private sector employers. Several states have introduced laws that regulate the use of AI in hiring or employment decisions. For example, New York City's Local Law 144 requires employers to conduct annual bias audits on AI hiring tools and disclose the use of AI to candidates. Similarly, Illinois' AI Video Interview Act mandates that employers notify applicants when AI is used during interviews and obtain their consent. Other states like Utah and California are enacting transparency laws that regulate generative AI use. Colorado's AI Act is especially notable as it's the first cross sector AI law targeting high risk AI systems, including those used in employment decisions. I'm going to talk a little bit more about Colorado's law in a minute. But first, let's cover a new AI anti discrimination law out of Illinois. And that is HB 3773, which adds new regulations to the Illinois Human Rights Act regarding the use of AI in employment decisions. This law, effective January 1st, 2026, prohibits employers from using AI in hiring, promotions, or disciplinary actions if it results in a discriminatory impact, whether that is intentional or not. An interesting provision of the law bans the use of zip codes as a proxy for protected characteristics like race or socioeconomic status, as this can lead to biased outcomes. Really interesting. Again, this concept that zip codes can lead to discriminatory outcomes. So employers have to ensure that their AI tools do not rely on data that could unintentionally or intentionally discriminate against protected groups. Additionally, HB 3773 requires employers to notify applicants and employees if AI is used in employment decisions. Further guidance on these notice requirements will be issued by the Illinois Department of Human Rights, so I will keep tracking this for you and report on it as more information becomes available. Circling back to Colorado, the Colorado AI Act, effective January 1st, 2026, is the first cross-sector law regulating the use of AI in critical areas like employment, healthcare, financial services, and education. This law targets high-risk AI systems that significantly influence decisions in these sectors. Employers using AI in hiring must ensure that their AI tools do not lead to discrimination based on protected characteristics such as age, race, gender. AI systems used in the employment landscape must undergo regular risk assessments and audits to identify and mitigate any potential biases. This act exempts narrow procedural tools like calculators or certain chatbots that don't influence human decision making. However, for AI systems that do impact hiring or employment decisions, employers must maintain transparency, document their processes, and ensure that AI is used fairly and without bias. Colorado Governor Polis' signing statement encourages lawmakers to support clarifying legislation in 2025 before the act's effective date. So stay tuned for updates coming out of Colorado. So, what are we tracking for 2025? Well, a lot in terms of AI privacy and tech laws. You might remember that California is taking significant steps to regulate AI in employment. While AB 2930, the legislative approach failed in 2024, the California Civil Rights Council has proposed regulations that would make it illegal for AI systems to harm applicants or employees based on protected characteristics such as race or gender. Under these proposed rules, employers will be required to conduct bias audits on any AI systems used in hiring to ensure that they don't result in discriminatory outcomes. Additionally, AI tools cannot replace the need for individualized assessments of an applicant's criminal history. I attended the council's hearing on these proposed rules in July, where there was significant discussion on the implications for employers. Though AB 2930 didn't pass, the council's proposed rules may advance and could determine the fate of AI-related legislation impacting employers in 2025. I'm going to continue to monitor this for you. As we focus on compliance, remember that FCRA regulated background check data is not in scope of the state data privacy laws, but remember that other employment related data is in scope in California. Employers must conduct bias audits for AI hiring in jurisdictions like New York City and notify applicants when AI is used as required by laws in Illinois and Colorado. In Illinois, avoid using zip code data in AI tools to prevent biased outcomes. And employers must also disclose AI in hiring processes, especially for generative AI, as mandated by Utah's AI policy. Regularly audit AI systems, conduct data protection and impact assessments when required, and stay updated on emerging regulations like California's AI Transparency Act. I love covering AI and its impact on employment decisions and have included several articles in this webinar's resources section, so check those out. That is our privacy, tech, and AI and employment update. So here is a quick plug as you get your questions in. And again, thank you so much for your engagement today. We have several outlets of information for you to consume. So if something piqued your interest, check out our resources library, blog, and Forbes articles to learn more. And again, connect with me on LinkedIn, where I post a short video covering new compliance content every single week. So let's take a look at your questions. There are a lot of them. Thank you again for the engagement. Like I said, over around 1,000 of you on here, and we have hundreds of questions. Thematically, looking at your questions, let's quickly, as I'm going through your questions, I want to quickly plug the Professional Background Screening Association, or PBSA, which is looking to help employers impacted by the challenges in completing criminal background checks in California due to date of birth redactions. They want employers to tell their story to lawmakers. So if you're interested in contributing, let us know and we'll put you in touch with the PBSA. As you know, there's a lot of trouble in getting information or criminal checks completed in California. So if you're impacted, let us know. We'll put you in touch with the PBSA. Speaking of California, tons of questions about unincorporated LA County, specifically if employers are allowed to ask applicants to self-disclose their criminal history during the hiring process. And the quick answer to that is no. Under the unincorporated LA County Fair Chance Act, employers can't ask applicants to self-disclose their criminal history at any point before making a conditional job offer. And then even after a conditional job offer is extended, employers can't request applicants to self-disclose their criminal history until the employer has received a criminal background report. The employer has to share that background report with the candidate before discussing their criminal history with them. Lots of questions about that salary threshold feature for HireRight clients. Again, if you are a HireRight client, you can implement a salary threshold feature where you can inform us as to whether an individual is expected to make over a certain salary threshold, let's say $25,000 or $75,000, which allows us to potentially report more information. And there's also various search steps. So there's 7 years, 10 years, variable, unlimited, regulated, unregulated. If you have questions about that salary threshold feature, let us know. We're happy to get you more information on that. Tons of questions about Pittsburgh and the restriction on pre-employment testing for medical marijuana patients. Again, yes, you need to adjust your panels to either remove THC if you are testing for THC in Pittsburgh, or you need to implement a process whereby you ask a candidate post-offer, make sure that you do it post-offer, not pre-offer, about their medical marijuana use, and then either test for marijuana or don't test for marijuana based on their response. So lots of changes going out of there. Again, expect the client communication coming from us and an article from me posted on Friday. With that, we are just about out of time. You can expect this webinar to be posted to the HireRight resource library shortly, and you'll also receive an email with your SHRM and HRCI credit with information next week. Before we leave, I want to let our friends in Florida and elsewhere impacted by Hurricane Milton know that we're thinking about them. With that, I'd like to thank you all for your time today. Please take 60 seconds to complete the webinar survey. I take your feedback very seriously, so please let me know how I'm doing. It is my report card, and many of you know that I reach out to you to get more information on your feedback. So please complete that survey. And I hope to see you in January for our 2024 year-end compliance review. Until then, thank you for spending a portion of your day with me today. Look for updates on Forbes and the HireRight blog and on LinkedIn, and we will meet again in 2025. Stay safe out there, everyone. Thanks again.